Be ready, guys. 5 seconds. Start. As you are aware, before the Constitution, we had the Federal Court as the highest court in India, of course, subject to the Privy Council then. When the Constitution was framed and when it was inaugurated, provision was made in Article 124 that there shall be a Supreme Court of India. As you are aware, in Schedule 2, Part D, some provisions were made regarding the salaries to be paid to the Supreme Court Chief Justice and other judges of the Supreme Court in respect of certain matters, as for example leave, pension and certain other matters. Provisions was made in Article 125. This is the position that was created under the Constitution. Now about 8 years have elapsed and a considerable amount of experience has been gathered. It is considered desirable that in respect of certain aspects of this question, namely leave of absence, pension and certain other conditions of service, we should have a law made by Parliament. That is the reason why this bill has been placed before this Honorable House. In respect of all these three subjects, I should briefly point out what the present position is under the Constitution and the need that has arisen for making some changes in the schedule. It has been pointed out that leave can be granted to a judge of the Supreme Court on medical certificate for a maximum period of 6 months, and while he is on such leave, his pay or his allowances would be rupees 990 per mensem. Then he can also go on leave otherwise than on medical certificate. There also the total period was specified as 6 months and he would be entitled to get the same leave allowance, namely rupees 990 per mensem. There might arise certain other circumstances when he would have to go on leave otherwise than under the two categories of leave which have been referred to by me just now. Technically, it is called for the sake of convenience as extraordinary leave. In the case of extraordinary leave, which a judge of the Supreme Court can take, a condition has been laid down that the total amount of such leave shall not exceed 6 months. In this particular case, in as much as he is going on leave, he will not be entitled to any leave allowance at all. Here I may also refer to the fact that in respect of conditions of service of all the High Court judges, an act was passed by Parliament known as the High Court Judges Conditions of Service Act. That was passed in 2004. Certain advantages or concessions were given to the High Court judges. That act is still in force. It has been very rightly readapted so far as the conditions consequent on the recent reorganization of states are concerned. Therefore, in respect of the High Court judges, we have got the Act of 2004, which we propose to amend in certain respects, and a bill in that respect will be considered by this honorable House immediately after this present item. Therein we have allowed a certain principle so far as the granting of leave is concerned. All the terms therein are fairer so far as High Court judges are concerned than what they were in respect of the Supreme Court judges. There a system was followed, and all that we have done in the present case is to take over that system and make it applicable to the Supreme Court judges with a few minor changes.